Good afternoon, and welcome to another edition of Florida Appeals Journal. I'm Jennifer Carroll, and today we're going to talk about what I think is a very interesting issue and one which a lot of folks don't know a lot about, and the law is not really that clear about it. Of course, that can be a lot of issues, but this one concerns damages, remittitur and additur. Remittitur is when, say, you get a jury verdict, one of the parties doesn't agree with it, the plaintiff defendant, plaintiff gets a big verdict, defendant says, hey, I'm moving for remittitur, judge, I don't think that verdict is supported by the evidence, so they file their motion. Or the plaintiff may say, judge, I want an additur, I think it should be more based on the evidence. So does a trial judge have any authority to change a jury verdict? And under what circumstances can the trial judge change that jury verdict? This is when we're talking about remittitur and additur. Something very important to know, what standards apply, what's the standard of review, what is a trial judge supposed to do when he gets that kind of motion? So let's look at that today. Very important issue. Got some great case law that will help you if you do have that situation. All right. Remittitur is something that's existed really for a long time. Basically, it started as a case law doctrine as far back as the late 1800s. All right. Now it's controlled by statute. You still got some case law there, but the statute supposedly lays out some vague standards. 768.74 and 768.043. Those are the statutes that you go by. Now, you also want to read Florida Rule of Civil Procedure 1.530 sub H sub 1. Okay. The party who is seeking remittitur has to strictly comply with the procedures set forth in the rule. The motion has to be served within the time for service of a motion for new trial, and then within 15 days after the return of a verdict or the filing of a judgment in a bench trial, the moving party may serve a motion for remittitur. The motion shall state the law which you're relying upon, the amount actually that the movement contends that the verdict should be, and the specific evidence that supports the amount that the movement contends the verdict should be. And you can also make a statement of the improper elements of damages that were included in the jury's damage award. Now, if the remittitur is granted by the court has to state the specific statutory criteria that it relied upon. And it also, and I'm going to give you some case law on this, it has to point in the record what evidence is supporting the number that it came up with, whether it was a reduction or an additur, an increase. Any party that is adversely affected by the order granting remittitur can reject the award and elect a new trial on the issue of damages only by filing a written election within 15 days after the order granting the remittitur is filed. Now, there is some variety on how parties handle this procedure, and we'll get into that also with the case law. I think that's very important that you know the cases on that. So courts do have discretion to rule on motions for remittitur, but the standards do have to comply with the statute 768.745. The court has to consider the following criteria. So here's what's in the statute. First, whether the amount awarded is indicative of prejudice, passion, or corruption on the part of the trier of fact. Okay. B, whether it appears that the trier of fact ignored the evidence in reaching a verdict or misconceived the merits of the case relating to the amounts of damages recoverable. C, 3, whether the trier of fact took improper elements of damages into account or arrived at the amount of damages by speculation and conjecture. So remember, general rule, you may want to make your jury verdict specific to that can help with future issues like this. And 4, whether the amount awarded bears a reasonable relationship to the amount of damages proved and the injury suffered. And finally, whether the amount awarded is supported by the evidence and is such that it could be adduced in a logical manner by reasonable persons. Okay. The statute also says that these factors are to be applied with caution and discretion. And because remember, the trial judge cannot sit as a seventh juror, so to speak, with veto power over the size of the jury verdict. So the judge just can't say, I heard that same evidence and I just think it's too high or I think it's too low. So I'm going to say this amount. No, can do. Very bad. You can't be a seventh juror. All right. There's an interesting case, Orlando Executive Park, 402 Southern 2nd 442. And it's a 5th District, 1981. And we'll be putting these sites on the sites for ease of reference. But that made clear when remittitur is ordered, the record must clearly show the amount of excess, okay? Or there must be an apparently high verdict teamed with extrinsic evidence of improper influence. Now, before I go into some of the cases, just remember, per the statute, if the parties don't agree to an additur or remittitur, then the trial court must order a new trial on damages. Okay, that's the case law. And what does happen is a party may just accept the additur or remittitur and then appeal the decision of the trial court regarding the additur or remittitur, and they can still do that. But the trial court has to always give the choice to the aggrieved party, the choice of either accepting the remittitur or they can have a new trial. It would be a new trial on the damages, and usually it's on non-economic damages where the fight lies. If that choice is not given, it's reversible error. I want to say a little something about preservation. So, how do you preserve this issue below? Quote, for preservation purposes, all that should be required is that it is clear on the record that the trial court fixed an additur or remittitur to which the party did not consent. Boom, that's it. That's how you preserve it. The Olivas case, OLIBAS, is 969 Southern 2nd, 1138. That's a 4th DCA case. And then there's a new case that came out in 22. That's the JL Property Owners Association case. And that's in the 4th, January 2022, 336 Southern 2nd, 291. That's a good case laying this out, really supporting these principles that I'm talking about. Now, I really like this case, the Arnold case. And before I hit that, I like the Adams case, and that's a Supreme Court case. That's back in 1981. And the Supreme Court at that time held the order for a new trial was deficient in that case, where it did not contain a reference to the record in support of conclusion that additur of a jury award was necessary to cure the inadequacy of the verdict. That's a good case. It was relied upon in many cases thereafter. And the Arnold case is one of those cases, and that's a 4th District case, 2015, held there because the trial court had failed to explain what in the record. The court may give an explanation, but you got to explain what is it in the record that demonstrates the need for remittitur regarding the awards for pain and suffering in that case, and the reason for the amount chosen. So the order, if you don't have that, the order is deficient, plain and simple. That is very significant because you don't get these remittiturs and additors very often. So sometimes it's hard to keep everything straight. So hopefully, I'm hoping our discussion today will help anyone facing this issue. Now, I like this quote in here in the Arnold case. A couple quotes I want to make you aware of. Quote, our Supreme Court has observed that, and they're quoting here, there is an element of speculation in most personal injury verdicts, but this is a matter for jury discretion. The court may review their discretion, but not the amount awarded unless shown to be clearly arbitrary. And in a recent case in 23, what's the site on this? Miami-Dade versus Borestain. That should be 3rd District, yeah, in 23. And we'll put the site on later. Quote, the jury is in the best position to make assessment of damages for pain and suffering, which is not one of mathematical calculation, but involves an exercise of their sound judgment of what is fair and right under the circumstances, which is what they hear, measuring credibility of the witnesses. They see what's happening. They're seeing the whole trial. And going back to Arnold, there was a quote, I think that's really outstanding on this issue. In granting a remittitur or an additur, there is always the concern that the trial court is usurping the function of the jury. What makes the concern more difficult is that the line of demarcation between the province of the court and that of the jury in this, as in all other mixed questions of law and fact, is often difficult to distinguish. Nevertheless, the law is clear that the trial judge does not sit as a 7th juror with veto power. And it cited other cases where they held that the trial judge was acting as a 7th juror and simply disagreeing with the size of the verdict. He exercised veto power over it. Quote, this a court cannot do. And so very, very good summary of the requirements that a court should follow and the lawyer should follow with respect. And another interesting ruling in the Arnold case, you can't just pay lip service to the elements in the statute, right? You can't do the boilerplate. And quote, an order which contains an incantation of conclusory statements and merely tracks the language of section 768.74 as reasons for the reduction and does not explain what in the record supports its conclusion for the need and amount of remittitur is likewise deficient. Really very critical and very good rulings and very good cases that we highly recommend. So, and that in a nutshell gives you an idea of what to look for when you're faced with this issue of remittitur or additur, increase or decrease of a jury verdict by the trial judge. I hope this helps. As always, any questions, let us know, and we'll do what we can to guide you in the right direction. Thanks again. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.